did you have a chance to speak with Miss Edison?
I did, Your Honor.
All right, we put you in a room for her. Give us just 1 second, okay?
I'm sorry, I did speak with her.
Oh, you did? Okay, perfect. Let me get her out. All right, Miss Edison, this is, oh God. All right, this is 242248 FY, the people versus Robin Edison.
Okay, pause for a second. This is where things get real. The judge is laying the groundwork, and notice how formal the process sounds. That's because this is the probable cause conference, a critical step where the court decides if there's enough evidence to move forward. Quick question for you all. Do you think defendants should always be granted bond while waiting for trial, or should past behavior, like missing court, completely shut that door?
Good morning, Your Honor. Good morning to your staff. Neighborhood Defender Services by Ken Riggins, P82125, on behalf of Ms. Edison, who appears via Wayne County Jail.
All right, Miss Edison, can you tell me your name?
Robin Edison.
The discovery on this matter?
I do, Your Honor.
All right, we need to set an exam date for Miss Edison.
And, Your Honor, before we do that, may we address bond?
Here's the thing. You can make your record. Go ahead.
Oh, yeah, I know I was in court a couple of weeks ago regarding Miss Edison, and unfortunately she did not make that date. It's my understanding that when I spoke with Miss Edison, she did not have transportation to make that date. Also, Miss Edison informs me that she has not had a tether on.
Waft, this is a heavy moment. The judge flat out says Miss Edison fled court when she heard about jail time. That's what's called absconding. And legally, it destroys credibility fast. Notice the tone. The judge isn't just frustrated, it's basically saying, I gave you chances, and you blew them. What do you think,
I didn't cut it off. I did not cut it off.
I gave her a personal bond, Mr. Riggins. I gave her a chance. She was in treatment court. She went to treatment. I gave her an option, and she absconded from treatment. And then she told the jail last time she was here that she had just used the day before. She was supposed to come in for a violation of probation or bond on her other case. And she came in and was supposed to be waiting. And instead she fled the court when she found out the recommendation was 93 days in jail. So here's what I'll say. And then Miss Edison, I'll mute you. Here's what I'll say. Removing bond. I'm keeping Miss Edison alive for a few months. And I'm not changing bond, period. She's a flight risk. She has a serious drug addiction problem, and she's gonna either kill herself or not show up. So, Mr. Riggins, you've made your record. She's been muted. That's my ruling. So let's find a date.
Your Honor, there's one last thing. It's my understanding that her father recently passed the 23rd of December. Her mother has dementia. At a very minimum, if you're not inclined to reduce her bond,
And there it is, bond denied. The defense tried pulling at heartstrings with family tragedies, but without proof, the judge isn't budging. This moment highlights the tension between compassion and procedure. Courts hear these excuses daily, but they have to decide who is telling the truth. Stick around, because what happens next is all about scheduling. But trust me, these little details shape the entire case.
Miss Edison will use And she'll show up when she wants to show up. I don't have any documentation at this court that there's been a death in the family. And Mr. Riggins, you hear it all the time, and so do I. Someone died in a family, or they start a new job tomorrow. I've heard it.
I
So,
understand.
all right, bond denied. Her bond will stay as it is. And then let's set a date, Mr. Riggins. I've got the 7th or the 6th or the 13th. Both are looking rough, but we'll make it work since she's in custody.
The 6th and the 7th, I have I am in a very long preliminary examination that is scheduled for 3 days. I can make the 20th, the 13th work. Unfortunately, that will probably be my first day available.
All right, well, the 13th is still. Well, that'll take us just over 21 days. Yeah, that'll take us to about 25 days. I'm finding good cause. We'll do the exam.
I can do the 9th as well if you're available.
The problem is I have a Wayne County prosecutor here for 3 hours a week. I have a Wayne County prosecutor from 9 to noon, which I can't do anything about that. That's what I have.
I understand, Your Honor.
It's frustrating. So we have to do January 13th. Mr. Riggins, she's in custody. You want to go at 10:30?
I have one matter scheduled at 9. Can we do like 11?
11 a.m. All right.
Thank you, Your Honor.
All right. Thank you.
Also, if I'm able to provide proof to the court of her father's funeral, may I present that to the court?
Sure. Yeah.
Okay. I'll contact the family if I can get proof. Thank you, Your Honor.
All right. Thank you.
You're welcome.
All right. Who's got Mr. Stevers?